a segue from licensing into our new general counsel, Gary Meyerhoff.
Okay.
This will be much briefer.
Much briefer. For those of you who don't know me, I started about 3 weeks ago after spending my career in the private sector, 20 years as a litigation partner at Denton's, which used to be Sonnenschein, Nant, and Rosenthal. For those of you who don't know what a Denton's is, it's the largest firm in the world that no one ever heard of. I am happy to work with all of you. Some of you I'm seeing for the first time, some of you I've met already. My phone will be available to you. I'm a litigator, so I guess I like arguing, so you can pick the topic and we can argue. If it makes you feel better, we can both pretend we're not arguing or that you're not representing your client's interests when you call me. It's fine with me. I'm learning as I go. One thing I know that I need to get involved in and to bring attention to is prosecutions and litigation and the process of prosecutions and litigation. It's one of my areas of strength administratively, as well as understanding tactics and all sorts of things like that. I've already noticed that there are inconsistencies in the way lawyers deal with each other in the process, inconsistencies across regions, inconsistencies amongst individual lawyers, prosecutors that you're dealing with at our agency. And I think that leads to, in some circumstances, expectations that are not getting met by you. You expect something because somebody else did it. I am going to bring order to that. That is my goal. I'm going to create written rules and guidelines and make everybody know where everybody stands, because I think it'll be better for you and for us. And that is a process that will continue over time. But because we have you all here today, I thought we would get started with a few points that I think we'd like to stress with you. And I'm going to ask Lisa Ogden to go over those with you. If you don't know Lisa, she is the deputy counsel, and she works out of Albany, but she's often here in New York, and she'll be working with me on these initiatives. I'm going to ask her to say some things, and then after that, we will take some comments, and again, in the context of suggestions for things to look at, not disagreements with what we're doing now or debates about that. So with that, I turn it over to Lisa.
Thank you. I want to thank you all for the opportunity to speak with you today about some of these things. As the chairman said and as counsel indicated, we do have a list today. It is brief, but it is important. Okay, we're really asking for your cooperation on these things so that everybody, so we can run the office smoother, so everything can be just better run for everybody as a whole. The basics. I'll start with this first one. It's the notice of appearance. Just reminding everybody to please submit a complete notice of appearance. And you need to submit it with each disciplinary proceeding, even if you submitted a notice of appearance to the licensing bureau at the time you did an application. We need a new one. You can find it on the website. We do include a copy of it with the notice of pleading to the licensees. Just please remember to do that. Number two.
Before you go on, Lisa, there was one thing I did want to say. I am conscious of the fact that some of you here are very experienced in dealing with us, and this is all going to be very familiar to you, and you're going to be bored. But you never know, you might hear something that you didn't know, and I beg your patience in any event. So,
thank you. My second reminder is to please respond to notice of pleading timely and in writing to avoid defaults. If we don't hear from you, we're going to default the matter. Okay? We're going to be moving forward with these cases. So if you have some understanding that we're going to contact you before we do that, please don't do that anymore. Do not expect that. Okay? Number three, don't wait until the day of the hearing to submit the plea offer, especially when the SLA attorney has communicated it to you several times beforehand. All right? It's inconveniencing everything, and we're thinking about ways to improve this, but right now we're really asking for your cooperation on that.
yeah, just a word about that. Obviously, if you I guess the point on a lot of these is, and look, I've practiced law for a lot of years, and I know what I have time to do and what I don't have time to do when things slip, but When there's an expectation that there will be no repercussions for not doing what is customary and fair to opposing counsel, to a hearing officer, opposing counsel that's going to come in from Albany to be at a hearing, you tend to continue to do it until somebody kind of slaps you and it hurts your client or it hurts you. We're looking at ways to make sure that some of these things, end up with repercussions if the conduct of the attorneys who are practicing with us don't change. You'll hear about those. The purpose of this is to give you a gentle reminder of those things that me coming into this would think lawyers would do generally, because I saw that for most of my career, not amongst all, but amongst most in federal and state courts. So anyway, please continue.
Number 4, in the plea offer, please explain that the licensee is back into compliance and that any necessary license applications have been submitted to licensing, and make sure that they have been submitted to licensing. Right now we're considering what to do about that formally, but please make sure that you and your clients are complying with that, and if they don't, they're at the risk of getting disciplined again. Number 5, we understand that there are some inconsistencies about the way that you deliver your pleas to our offices. We are working on procedures, a uniform procedure for that as well, so you'll be hearing more about that on this fairly early.
Yes, and litigators, people who are representing clients, you should routinely check our website for alerts on new processes that we've instituted. That will be one that we will absolutely have an advisory on. What the new and final procedure across the board is for sending in a plea offer, so there's no confusion about that. Okay.
Number 6, be on time to the hearing. Some of you know who you are routinely late for these hearings, okay, and it's having a negative impact on the rest of our day, and quite frankly, it's inconsiderate. Also, unprepared. If we previously provided you with the documents that we intend to introduce at the hearing, and you want to have them at the hearing, please bring them. I hope, moving forward, we don't want you expecting to get another copy at the hearing, okay? So please continue that.
Or to argue that you're prejudiced by not having it and force us to go to the task of showing the document in which we delivered it to you. This is, again, just a courtesy to those who have come to expect that they will get whatever they need when they get to the hearing. It's not going to continue. That's what they're expecting.
And lastly, this is on hearing continuations. Some of you have come to expect a standard or a routine continuation of the hearing, and I put it in quotes for your words, those are not mine. There's no such thing as a standard or routine continuance, okay? So moving forward, we're going to put forward some reasons for continuations in the future on the website soon, so you can expect that as well. That's really all I have for today.
On continuances, I will say some of the things that I heard are a little surprising to me, even though I understand this is a different scenario than the forums that I'm sure many of you also practice in. Obviously, good cause is good cause, and we are going to try to fashion a group of rules. Look, when I get a new case in civil court, I look at the judge's individual rules for how I deal with continuances. Well, we're going to have something like that too, and we'll put it on the website, and everybody will know what it is, and everybody will know where everybody stands, and hopefully there won't be any confusion. So, with that said, our attorneys are obviously going to follow whatever rules we put in. I mean, I think that's why that benefits you as well, and you will appreciate that. Obviously, there's give and take between lawyers on cases, and I think that to some extent, some give and take that has been given historically or by individuals over time has led to a level of inattention to the ordinary rules that govern lawyer relationships in litigation. And I want to try to kind of correct that direction with some individual and specific rules on some of the things that cause those kinds of conflicts. So with that said, thoughts from the audience. Please.
Can we get a consistent fee schedule? I have a declaratory really long now with like certain fee schedules for certain things. But like, for instance, somebody violating DJ first time could be 1,000 one day, and then I get 10,000 the next time. Can we get a legitimate?
The members can't do that.
So that they have an expectation of what their fine is going to be, because it's not fair. If they're going to violate, let them know that if you violate, you're going to be paying 1,000 the first time, and maybe like we do with the sale to minors, 3,000, 6,000, 9,000, and then you're on.
So
Or
they can decide at
10,000.
what point they want to violate and what's worth it to them and not? I mean,
Hold on.
So here's the situation, which I don't know that you're really taking into consideration. There is a level of guidance on what the fines are if you don't have a negative record. If you bring someone in that has multiple violations over the course of 2 years or 6 months or 5 years or whatever the case may be, that's why there's a board. At that point, we weigh what that adverse record is, what the activity was that went on, and we agree, at least hopefully two of us agree, on what the fine amount is. So to ask for guidance on that is impossible because it's taken on a case-by-case basis. As far as what the numbers are, such as 3,000 for your first sale to minor, 6,000 for your, I believe that's available on our website.
The only thing that's set in stone are the non-calendar items. Even this idea that a second sale to minor is 6,000, that's just, if you look at the history, that's a traditional penalty. That's not set in stone. The only thing that's definite are the non-calendar items. And that's because over the years we've gone through and figured out these are the routine items. A first-time sale to minor. Depending on if you're a liquor store, the age of the minor, there are variations that are provided for. All right, if you have no history. Right? You're talking about a failure to conform to the application. There are all degrees of failure to conform to the application. So we can't come up with one for that. The ones that are in the non-calendar delegation are ones that, there's some certainty as far as there's a certain set of facts, and we can plug those cases in there. And it expedites the processing of the disciplinary.
I will take from your comment from the audience that what you're looking for is more precision in the offers you're being given on no contest. We will take that under advisement. It's a fair point. I don't think we can be as specific as you'd like.
And also with the 3 zones, excuse me, I'm sorry.
Go ahead.
With the 3 zones, perhaps, while you're trying to review that, because there is a difference. Sometimes another zone 2 may give you some more guidance in terms of what will be considered for an offer, and then you might not get something.
The question that's been asked for those who are on video is, will we consider guidance across zones and try to come up with some consistency? The answer to that is yes. We're certainly looking into that. Yes, go ahead, please.
I was going to say just the opposite of what was stated. I can't tell you how many times I've called counsel's office and said, look, I'd like to negotiate a settlement. And then I'm told, no, there's a flat line bottom. Now, I'm hearing that there is no flat line bottom, but I'm telling you that they're telling us that they will not go to the board unless there's a certain number, and that's because that's what they were told, or words to that effect. So, I'd like, because I've done this a couple of times, and I guess my aggressive ways have gotten me in trouble, but I said, can I speak to your supervisor? No, that's it. It ends with me. So I have a big problem in, number one, asking for a conditional no contest, but assuming I want one, I'm being told a lot, no, we will not.
I don't remember the last time you ever did ask for one.
No, yeah, true. But I can tell you one I just now, and I was told, no, I'm not going below a certain number, and I was also told that the reason I'm not going below a certain number is there's a lot of paperwork. In other words, if I go before you and I say I want X, and then you say, no, it's got to be Y, apparently there's a repercussion against that attorney for even suggesting lower.
One, before you can answer, but I can guarantee you that there has never been a repercussion or even a comment to any attorney about an offer.
But what happens more times than not?
Well, there's a new guy here, and he'll take care of what you're talking about, because that should not be happening.
Just to finish that thought, what gives me pause is they said, I will not bring it up unless you put in X. And then, once you get in front of the board, maybe you can make some sort of speech that will bring it down. But that gives me a lot of pause. That's why I'm reluctant to do it in the first place. But if
I hear what you're saying. I have a few reactions. Number one, the thought that you're going to have an appeal process to talk to somebody else about a plea offer, I will consider that, but I can't see that happening.
Hold
on.
Let
me tell you something else.
Okay.
Number two, there may be many reasons why a plea offer is given at a certain level, some of which aren't disclosed to you. I suggest that you not seize so much on what the lawyer happens to be telling you as his reason, which he's probably doing to try to end the conversation with you. He's instructed in a certain way and will be under my leadership as to what offers to make and what offers not to make. And I'm frankly surprised that you're so concerned about the reason why he's telling you he can't get below a number, as opposed to what the number is.
I'm not concerned about the reason. I'm just being told I can't go below that number, period. Let's end the conversation.
Well, and in certain circumstances, that may be the case.
Well, as somebody who's both inside and outside of this organization, I after 45 years, there are very few things I can't survive.
I will take it under advisement. It's a fair point. I will consider it, and I will talk about it.
All right.
But just back quickly to that point, there is, other than what Tom described, there is no guidance that the board as a whole or individuals have given the lawyers as to what the offer should be.
I understand.
No, I'm just telling you for everybody, not just you. He's in charge of that, and he'll determine what those are.
As I just said, what bothers me is in order to get the CNC in front of you, I've got to hit a certain minimum number.
Well, and they probably, to his point, probably said, this is where I'm going, I'm not going any further, and gave you an alternative reason why.
Yeah, the reason is that no.
Well, as we're having difficulty ending this conversation, I can see why they would do that.
Let me go on to another point, because it was stated by Lisa, but I'm not sure that in practice it's done. Yes, if we're not there at 10 o'clock, all hell breaks loose. But if the attorney for the authority starts saying, well, I need the cop, I need this, I need that, there seems to be a lot of leeway the other way. So I would ask that, what's good for the goose is good for the gander as well. If we are...
I think she's talking about people who are habitually late and don't take care to make sure that they're behaving like responsible attorneys before this tribunal. And I'm not talking about latitude on particular circumstances where it would make sense for an ALJ to make a decision about whether to wait or not. So I think the point was a general one.
That brings me to my next point about the ALJ. It seems to me that if you're talking about something like a continuance, and then you're going to set the guidelines, that cuts the independence of the ALJ in terms of, there may be legitimate reasons for it.
He's setting them to go through me. So,
but the independence of the ALJ then is somewhat compromised.
We are not taking away the independence of the ALJ. We are talking about your request to us for agreement to continuances and issues like that.
I'm sorry. Then I meant during the course of a hearing, something happens, and then I ask for a continuance. Are you saying that the ALJ is free to say yes or no?
The ALJ will decide what the ALJ wants to decide.
Well, okay, that's refreshing.
it's more, I think it's geared towards what our lawyers have been agreeing to that they may not be agreeing to anymore, which means that the ALJ is going to have to decide.
No, that's fine, as long as you're telling
All right, then I think we're in agreement.
All right.
Please.
Also, I don't know if this is a problem.
He's older, I'll wait.
No. Article 78, can I discuss Article 78 with you in private, or do you want an open discussion?
That really isn't the subject of what we're talking about right now. So if you want to raise something with me later.
But what it relates to, I had a very recent Article 78 that I commenced, and it dealt with the civil penalty. And I know going back to when I was at the authority would enter into a stipulation saying we'll hold off on the enforcement of the civil penalty until such time as the thing is resolved. You even put into your stipulation that you must bring it to the appellate division by such and such a term, or whatever you want to do. That's been taken away. It adds to a lot of paperwork that has to be done in terms of going to the Supreme Court and going to the appellate division.
Okay. I thank you for bringing that to my attention. That is the kind of thing I would like to talk about. You see a change, you want us to consider it, we will look at it.
So, I just talked to you.
I don't have an answer for you.
No, I don't expect to answer, but my question is, do I direct these comments to you? Because I do more than Article 78 than anybody else.
You can direct them to me.
Okay, that's thank you.
Please.
My name is Rob Bookman. We haven't met before. Welcome to the Funhouse, Gary. Look forward to working with you. And just brief comment on some of the excellent points that Lisa raised is that, and we do a lot of CNCs. We're the opposite. And that the good-looking young guy who was at the front row, who left before, that was my son Max, who was also disciplinary. But he has come to me from time to time saying, I'm trying to reach this lawyer, whose case it is. I keep getting his voicemail. The hearing's coming closer and closer. We want to enter into conversations for settlement. We don't get a call back sometimes to the day before the hearing. We're now nowhere close to what we had hoped to be, and they're going to oppose, and the counsel and the lawyer says we're going to oppose an adjournment request because it's the day before the hearing. Come to the hearing. So sometimes it's because they're busy, but sometimes it's a tactic, and
How is that a tactic?
it's a tactic because for weeks we haven't prepared the case because we've been hoping to get into a settlement conversation. It's now the day before. Don't have a reasonable settlement conversation. We're now told the day before that we're not in the same room. The reasonable professional thing would be, look, I've been trying to reach you for 2 weeks.
I do not consider that a legitimate tactic. I will talk to my team about that.
Neither do I. Thanks. We want to settle, most of it.
And we don't want to go to hearing if we don't have to.
Once we can't settle, we get to him.
Sometimes the communication problem is on our end. Sorry if I interrupted your.
No, I said once we can't settle, we get to him.
I want you to get as many laughs as you can. So, I don't know enough to know how often it's our fault and how often it's your fault, but I am not naive. I'm sure that there are problems on our side with getting back to people, even in circumstances where the call could have resulted in resolving a case. I will look into it. Seeing no other hands
Anything
raised.
in Albany, Buffalo?
Any questions? Yes, in the other region. Anybody?
Not about legal. I just have 2 quick questions. Can you tell me currently what renewals are available online?
The only renewals that are available online are for permits, for trucking permits. If you go to our website and you...
Okay, I'm familiar with those. Yeah.
Okay.
Okay. And then I have a quick question about a restroom waiver when there's only one restroom in an establishment. What are the guidelines for the capacity, the occupancy, when a waiver will be granted?
74 or less.
74?
Or less.
74. So if it's less than 74, 1 bathroom waiver is good.
Correct.
That's right.
Thank you.
All right, I want to thank you all. It was wonderful spending the day with you again, as usual. The only thing I can add, we continue to have an open door policy. If you do, as I said before, if you do have a complex licensing application that you know is coming, 1, get to us as quickly as possible, and 2, get it in as quickly as possible, obviously. We are working on this issue daily, and I agree with Mr. Bookman. We recognize this as a crisis, and I'm here to fix it, and I think everybody else is as well. We want to be part of the solution, as I'm sure you all do too. So thank you all.